So why patent reform? I have a quote here that talks, this is from a congressman. It talks about how there is an undue and unsound desire to grow suddenly rich without work, and that patent law is fostering that gambling spirit. I'm being slightly disingenuous here because this quote comes from Representative Stephen Hurlbut, who was in Congress in the 1870s. And this is part of the congressional record when patent reform was debated after the Civil War. Back in 1878, there were calls to reform the patent system. On one side, you had farmers who hated patents. They saw them only benefiting urban areas and wanted patent rights severely curtailed. This is a historical point. The Patent Office, in its early days, spent about half its budget preparing an agricultural report, not having anything to do with patents, but that was to appease farm interests. The people really driving the reform effort back then were the railroads. These were labeled as the liberals at the time. And what they said is they wanted balance between inventors and innovators. They considered themselves innovators. They were the people who implemented technology. And they wanted more monetary benefits to flow to the implementers of technology. In other words, them. Then we also had opposition, which was the political machines of the day. You might recall political machines from history class. They tended to represent sort of urban working class interests, immigrants and so forth. And their goal was to obstruct everything and prevent any reform from taking place. And eventually they did prevail. They were able to prevent a patent reform bill introduced by Senator Bainbridge Wadley from New Hampshire that had a lot of changes for patent law of the day. And just to give you a little bit more context here about patent reform from after the Civil War, although the legislative efforts failed, the Supreme Court ended up stepping in and taking a number of patent law cases in that era. And if you look at their opinions and compare them to what was being proposed in the legislature, the Supreme Court pretty consistently took the position of the railroads or the liberals and did curtail things like how patents should be construed and how damages were calculated. So that this sets some context, and I'm going to come back to this a little bit later to see how some of the proposals from 1878 are eerily familiar to what we see even today. So today, let's start by looking at judicial efforts to reform patent law. I had the comment from Representative Hurlbut about the gambling spirit, getting rich without work. Well, in 2012, the Supreme Court decided the Mayo versus Prometheus case about patent-eligible subject matter for DNA. And if you read that opinion, they make a comment about the problem of rent seeking. And what that means is unearned income or kind of having an economic free lunch. The same concern that was expressed back in 1870s. The Supreme Court is also currently deciding the CLS Bank case. We'll hear a little bit more about that later today in another presentation. But it deals with the question of what is eligible for patent protection. And that's a key question because a lot of patent troll, alleged patent troll patents deal with sort of abstract concepts that many feel should be deemed ineligible for patent protection. So the Supreme Court, just as what we saw after the Civil War, is somewhat leading the charge in terms of implementing actual changes to how the patent laws function. And it's still an open issue. The Supreme Court continues to hear patent law cases. They've heard in their current term a substantial percentage of their docket has been intellectual property or patent related. Also on the judicial front have been proposals to amend the Federal Rules of Civil Procedure. At the moment, these are not poised to be implemented. There have been proposals to both change the discovery requirements. There's a concept called proportionality that's been introduced to try to limit discovery requests. There's also a proposal to eliminate some of the forms that are related to filing patent complaints, in particular Form 18, which is a model patent complaint. And some of that stems from the Iqbal and Twombly cases on what is sufficient notice pleading. At the earliest, the Federal Rules of Civil Procedure would not be amended until December of 2015, so more than a year away from any changes being implemented on that front. But when you look at those changes, very mild. They address some of the least significant concerns about patent trolls and do so without giving courts any more teeth in their enforcement mechanisms. So pretty lightweight changes to the rules of civil procedure. They do nothing to sort of rein in some of the outlying district courts or outlying district judges who have procedures wildly different than others. There also have been some administrative efforts from the executive branch of the federal government. The White House has launched a program to train patent examiners at the Patent Office on functional claiming. While good in theory and useful perhaps in curtailing these sort of abstract and broad claims that appear in patents that patent trolls assert, it remains to be seen exactly what this training is going to entail, whether it will be effective or how long that training effort will be carried forward. So it's a little bit hard to say what effect that will have. They also set up a website through the Patent Office that includes information for the public on patent trolls. Now, both of these proposals are sort of feel-good sort of publicity stunts more than substantive reform, but the training could have some effect at some point. The Patent Office, too, has made a proposal to require patent owners to disclose the true owner. I mentioned earlier that there's a use of shell companies sometimes, and this is meant to address that. It's probably one of the least significant problems that patent trolls present, but the Patent Office has suggested the most draconian penalty, which is that the patent would be abandoned if that information is not disclosed. What I didn't put on the slide, but we'll mention briefly, is that the Federal Trade Commission has also initiated some enforcement actions against an alleged patent troll, saying that some of their practices are deceptive trade practices. I'll come back to that a little later. What's received the most attention of late are some bills that have been proposed at the federal level to reform the patent statutes and address the activities of patent trolls in particular. Now, the leading bill on that front is called the Innovation Act, introduced by Representative Goodlatte from Virginia. Now, this bill actually did pass the House in 2013 and is currently with the Senate. What I can say at the moment is the bill looks dead at the moment, in the sense that the Senate is unlikely to take any action on this, and they're more or less stalling that bill. We probably won't see anything on it until the next term. We've got an election cycle coming up. It's unlikely that any action is really going to take place this term. But nonetheless, the Innovation Act had some provisions to increase the pleading requirements for patent cases. So plaintiffs would have to disclose much more detailed information in order to present a claim for patent infringement. It would also place some limits on discovery, really kind of shifting the timeline for when discovery takes place during patent litigation. Most important in the Innovation Act was a provision that would implement fee shifting. So the US legal system is based on the principle that each party pays their own costs. This would change that for patent law, saying that the loser pays all costs unless their position was substantially justified, whatever that will end up meaning. So that's really very significant and probably the most dramatic change that's been proposed here. There were some further provisions regarding transparency, requiring disclosure of who the true owner is, some more technical aspects as well, dealing with changing the provisions from appeals from the Patent Office to the courts, and changing patent post-grant review proceedings. But as I said, the most important provision here would be fee shifting. There's a number of other bills that have been circulating. In general, the Senate has taken the approach that they're going to tackle the problem in a more piecemeal fashion. So the Innovation Act addresses a lot of different things all in one bill. The Senate has presented a number of piecemeal proposals that have provisions that line up somewhat closely with certain things in the Innovation Act, but in a more piecemeal fashion. But there's no shortage of these bills. Really doesn't seem that any of them have any chance of coming to a vote within the next year. And as I said, even the Innovation Act doesn't seem like it's poised to be enacted, at least in this term. Aside from the federal level, there's also been state efforts to address so-called patent trolls. And 14 states now have enacted laws that deal with patent troll activities. And there's a few more on their way to being signed into law, as well as other states sort of still debating this. The state that led the way in these efforts was Vermont, and they're sort of a model for the other states. Most of these are based on principles similar to Baby FTC Act. So it's from the standpoint of being consumer protection and preventing deceptive or unfair trade practices. That's the general tenor of these laws. So the Vermont law sets out some non-binding factors that are assessed for bad faith in patent assertion. So they look at lack of information in demand letters, setting unreasonable response periods, not basing a license offer on reasonable estimates of the value of the license, that the claims are meritless, that it's deceptive, etc. A violation of the law allows for equitable relief, fees, and damages. There's also some provisions in the law that provide factors that counsel against bad faith, such as that you're practicing the invention or that you're a university. Now, just to comment on these laws, they raise some pretty significant preemption concerns, because when you start looking at things like a demand being meritless, that looks like substantive patent law, which is exclusively a federal question. So a state passing laws on that question are almost certainly going to be challenged on the grounds of being preempted by federal law. So while this has become sort of a hot topic lately in state legislatures, that everyone's sort of jumping on the bandwagon, passing these anti-troll laws, there are some very real questions as to whether these laws are going to hold up and survive challenges. For the time being, practitioners and patent owners should just be aware that these laws have been enacted in a number of states, and so depending on where you might have activity, you'll definitely want to check state laws and verify whether any patent demand letters that you might send raise any concerns under these state laws. So now we've talked about some of these reform efforts. How do these relate to those three factors that the Government Accountability Office identified? Unclear and overly broad patents. Well, on that front, the training efforts at the Patent Office might help. Most likely to make progress on that front would be continued decisions from the Supreme Court that clarify the proper legal standards. So perhaps the CLS Bank case may provide some insight there. Number two, really the litigation expense aspect. The Goodlatte bill, the Innovation Act, would potentially make a difference there in implementing fee shifting. Otherwise, there aren't really any proposals to limit damages in patent cases in any meaningful way. So damages themselves aren't really being addressed by any reform efforts today. Now, number three, the increasing recognition that patents are a valuable asset. I think from a historical perspective, this is somewhat false in terms of actually being a problem. You have to really take a narrow view from the perspective of multinational companies since the 1990s in order to really see that trend. If you look more broadly, I don't know that that holds up. So I have a little graph here, table. I won't spend a lot of time on this, but I just thought it would be interesting to compare the reform efforts of today, at least the leading ones like the Innovation Act, to what was being proposed after the Civil War. And what you can see here is that a lot of what's being proposed today was proposed after the Civil War, and they didn't pass then. So I'm a little bit reluctant to say there's much chance of some of these things actually passing today. We'll see. I could be surprised. But a lot of these reforms have been proposed, and people have been complaining about the exact same things for well over 100 years. And there haven't really been many solutions in the interim. Certainly some of the things people complained about 100 years ago have been resolved through the courts or other legislation. But if you look at some of the biggest complaints that critics have about the patent system, even today and the same after the Civil War, things like a presumption of validity or user liability, these weren't even being addressed by the reform efforts. So another development recently has been deceptive practices lawsuits. And the FTC had started to bring an enforcement action against an alleged patent troll, this company MPHJ. And the Vermont Attorney General also brought a state action, not under the new anti-trolling law in Vermont, but actually under pre-existing unfair trade practices law. So similar to kind of authority that the FTC has. When the FTC started their enforcement action, the company brought a declaratory judgment action and went on the offensive in federal court. Now, what the complaint is here, what the underlying dispute is deceptive practices. So among the allegations that the FTC had made was that this patent owner had sent over 7,000 letters to accused infringers, and those letters said that many companies had already agreed to licenses of this patent, which dealt with supposedly scanning documents directly into an email. And the licenses were $1,000 to $1,200. In fact, the company had not secured any licenses at that point. So it was pretty much a straight up lie, according to the FTC, that there were licenses already secured. And then they sent an additional set of letters, more than 1,000, where they still said they had many licenses and they had secured only one. So that's sort of the tenor of the FTC action, that it's deceptive to lie in patent demand letters. The plaintiff, which is the patent troll in this federal case, is arguing that these actions are barred under the Knorr-Pennington doctrine. I won't go into that in detail, but it's a series of cases saying that you have a right to petition the government, and that includes making an assertion of patent infringement, and that can't be restricted. The Vermont case, very similar. The alleged patent troll tried to have the case removed to federal court, but a federal district judge said it didn't involve any federal questions, so it went back to state court where it currently resides. So I just have a couple of example letters here, just to point out a few things about how you might frame a cease and desist letter today in view of some of these deceptive practices lawsuits and the new state anti-trolling legislation. So in this first letter, you say that you represent a company, they desire to license a patent on similar terms to those already agreed to by your competitors. Please respond by tomorrow. So under the state laws, saying respond by tomorrow, well, that's an unreasonably short period of time, and evidence and a factor that weighs towards having bad faith. Similar terms to those already agreed to by your competitors. Well, let's say, as a factual matter, you have secured no license to any competitor of this infringer. That's a situation similar to those FTC actions I just discussed, and could be deemed a misleading and unfair trade practice. You'll also notice that this letter doesn't ever identify who is the patent owner. So that's another potential factor for bad faith. So those are all things that could raise some questions under these new state or FTC enforcement scenarios. Here's just another example. This includes more specific information saying that the person sending it represents the exclusive licensee, so they have rights in the patent. They identify with particularity what they say is infringing, which particular product, which model, and they propose a royalty that's 0.05%, which we'll just assume is low enough here that it corresponds to a reasonable assessment of the value of the patent. And they get 1 month to respond. So let me talk a little bit about tactics that can be used to defend against patent trolls, kind of to avoid having problems with them. There's no silver bullet here, there's no magic formula, but probably the most important thing to keep in mind in the modern business context is to seek indemnity. Today there's lots of vendor agreements, there's lots of joint development taking place, and the easiest way to avoid problems with patent trolls is to make them someone else's problem. So you can draft your agreements with vendors with that in mind and shift the responsibility to whoever you think should have it. You can also engage in clearance or monitoring efforts, doing freedom to operate studies. What some people don't like about the patent system is that it's based on strict liability. You don't have to know about the patent. You don't have to have knowingly or willfully have infringed the patent to still run into some liability. This means that the patent system imposes a duty to monitor the state of the patent law if you want to completely avoid infringement. This is most important when you look at the mergers and acquisitions context. When you're acquiring a company, you want to make sure you've done due diligence so that you're not buying your way into a patent lawsuit. Another suggestion here, this comes from the response that the railroads had after the Civil War. They created anti-patent pools. They shared information. They tried to build up repositories of prior art to try and invalidate the patents that these patent sharks had and would assert against them. What you could include within that is defensive publication, which is to say publishing information of a technical nature to try to prevent patents, broad patents, from being issued to patent trolls. Another possibility here would be litigation insurance. At the moment, I've spoken to an insurance agent about this once at one of our past seminars, and insurance companies don't really know what to do with underwriting policies for patent infringement, and so the rates aren't particularly attractive. So you don't see many companies taking out that insurance, but it is available. After you've gotten a demand letter or have been sued, you can think about a declaratory judgment action, assuming it's just a demand letter, to steer away from plaintiff-friendly venues. It's expensive, but the procedural benefits are very substantial, so it's not necessarily an easy decision there. You could also leverage efforts of other defendants, try to see if they have prior art that may not have become public record in past enforcement actions. You can take the patent back to the patent office to be reconsidered. You can also minimize the cost of defense. If patent trolls indeed are basing their demands on a calculation of the cost of defense, knowing that the defendant has hired an attorney who's from a smaller firm at more reasonable Midwestern rates changes the calculation compared to knowing that you've hired a big law firm attorney from out east billing over $1,000 an hour. So I'm going to kind of skip past my last slide here in the interest of time, but certainly we've seen that the current reform effort is eerily reminiscent of things that have been attempted in the past. At the moment, there hasn't been a lot of momentum gained on the legislative actions, but we're going to see some action in the courts, and we're going to have a number of talks later today that touch on some of those themes. So thank you very much for your time. If you have questions about my topic, please feel free to stop by and ask me a question in one of the breaks or submit a question on our forum. Thank you.
Thank you, Austen. Next up, we have Kendra Hogan and Rochelle Martin.